Ajmair book criminal passage number 14 recorded by B&A Shorthand Studio, dictation speed 100 words per minute. Ready, start. The only crucial point which was vehemently argued before me was the plea of alibi of the petitioners. Full stop. According to learned counsel for the petitioners, on the day, date and time of alleged incident, petitioner being constable of elite force was present on his duty, while petitioner being student of BSc forestry at Pakistan Forest Institute Peshawar was in the hostel for preparation of forest mathematics paper to be held on the next date of occurrence, that is 24th April 2014. Full stop. We are confronted with the record, wherein the pleas of alibi of both the petitioners have been reinvestigated by special investigation team, constituted by Superintendent of Police on the written requests of the petitioners. Full stop. No doubt, during inquiry, the special investigation team has recorded statements of some officials of the elite force for presence of petitioner with them on 23rd April 2014, but there is no mention in their statements to specifically depict that he was present on his duty on the day and relevant time of incident. Full stop. Similar is the case of petitioner, in whose favor Director Forest Education Division has issued a letter certifying that he was present in the hostel in the evening of 23rd April 2014 for making preparation for the paper of forest mathematics, which was to be held on 24th April 2014. Full stop. Para. Admittedly, he has furnished this certificate on the basis of statements of students and program officer. Full stop. He is not warden of the hostel to know about each and every moment of presence of each student. Full stop. Similarly, statements of the students recorded during investigation, do not show specifically the presence of petitioner in his hostel at the time of occurrence. Full stop. Report of the special investigation teams reveals that no final opinion qua innocence or guilt of the petitioners has been given therein, rather the inquiry has been held pending till decision of the case by the court, which seems very strange because the prime object of the inquiry is always to take the same to its logical end. Full stop. No doubt, opinion of the investigation agency is not binding upon the court, but the special investigation team ought to have taken the inquiry to its logical end by furnishing its final opinion qua guilt or innocence of the petitioners in the light of the statements recorded. Full stop. This exercise on the part of the special investigation team being not in consonance with law, is highly deplorable. Full stop. The investigating officers of the two consecutive investigations, have not declared any one of the petitioners as innocent, nor have placed their names in column number 2 of the challan, nor have recommended their discharge from the charges. Full stop. Had they found the petitioners innocent, they would place their names in column number 2 of the challan or would have recommended their discharge. Full stop. No doubt, plea of alibi like any other defense plea, taken at bail stage, is essentially required to be examined by the court with a degree of care and caution. Full stop. No inflexible rule can be laid down that plea of alibi cannot be considered at all, at bail stage, but the same, in every case is to be considered in the context of its own facts and circumstances, full stop. As regard plea of alibi in the incident cases, as discussed earlier, the special investigation team has not taken the inquiry to its logical end, from which any concrete inference can be drawn one way or the other, therefore, in these eventualities, keeping in view the peculiar facts and circumstances of the instant case, now it would be the trial court, who shall determine the veracity and credibility of plea of alibi by thrashing the defense evidence, full stop, stop writing please.